Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip, we are continuing on with the changes that the Georgia Association of Realtors has made to the 2021 contract package. So please, I will link below. Please watch all the other videos in this series, and Maximum One hosts a 3-hour free CE virtual class called 2021 GAR Contract Changes. The school is the Georgia Real Estate Academy that actually offers those CE credits, and it is hosted by Maximum One Realty Companies. So I'll link the calendar below. So would love to see you in one of those classes, several of them throughout January, and please watch these video tips. So today I'm going to talk about the changes that they made to the purchase and sale agreement. Good news is not that many at all. So one of the things, I'm just going to go through them, and I believe you guys will be excited because there really are not a whole lot of changes whatsoever. So the first change is in the earnest money section, and under paragraph A7, where it talks about earnest money, where you check the box regarding the form of the earnest money, they have added ACH. So now it has check, ACH, cash, or wire transfer of immediately available funds. So they've added that. And then I believe I have referred to this in some of the other videos I have done. But what GAR has done universally throughout all of the forms is they have changed the terminology a bit. So for agents like myself who have been practicing over 25 years, we are still probably going to slip and use the old terminology. But instead of calling the agent or the broker that works with the seller the listing broker or the listing agent, now throughout all the forms, that broker is referred to as the seller's broker. And instead of referring to the broker and agent that work with the buyer as the selling broker or selling agent, now that is referred to as the buyer's broker. They have done that for clarification with the public as well as agents in general. So I am just letting you guys know in advance, old habits are hard to break. So I will try and correct myself. But this is a great change that GAR has made for clarity reasons. Instead of selling broker, it's now buyer's broker. Instead of listing broker, it's now seller's broker. So now it's more clearly identified the broker working with the public seller and the public buyer. And that has been changed throughout all of the forms, anywhere it is referring to one of those specific brokers. The next change they made, and this is going to be a nice discussion for you guys as agents to have with your closing attorneys, or better yet, to have your clients have with the closing attorneys, is under paragraph B3, where it talks about the prorations, specifically where it talks about the ad valorem property taxes. So we know, you guys know that if the tax bill for that county is not out yet, that the closing attorneys typically are going to use the assessment based on last year, and the burden is on the parties. They are charged with prorating between the two parties when an actual tax bill comes out, or if there are any corrections that need to be made there, or anything that has been pending. This year in 2021, the very last sentence of that paragraph B3C under prorations, where it is talking about the tax bill specifically, they have added the sentence, 2 sentences that state, the liability to the county in which the property is located for ad valorem real property taxes for the year in which the property is sold shall be assumed by the buyer upon the closing of the property. Buyer agrees to indemnify the seller against any and all claims of the county for unpaid ad valorem real property taxes for the year in which the property is sold. So again, that is going to be a discussion that you are definitely going to want to put your buyers in touch with your closing attorneys prior to closing to make sure they have a full understanding of the taxes that will be of the tax bill for that property, if there's anything outstanding, what's going on. Especially Fulton County and DeKalb County have had a lot of issues with their ad valorem property taxes, so just take a look at that. The next thing, not quite sure how you guys are going to feel about this one. Under the section, under paragraph B8, where it talks about inspection and due diligence, GAR this year for 2021 has tried to more clearly explain the buyer's rights with respect to, in this term where it's talking about inspecting the property, it does refer to perhaps an independent home inspector, but it also means inspect as in checking it out or entering the property. So it says under paragraph B8A, right to inspect property. Upon prior notice to seller, buyer and or buyer's representatives shall have the right to enter the property at the buyer's expense and at reasonable times, including immediately prior to closing, to inspect, examine, test, appraise, and survey property. That's been there. That has already been there in 2020. This next sentence is what they have added for 2021. The right to enter shall include the time period after the end of any due diligence period to, among other things and without limitation, meet contractors and vendors, measure for renovations, and confirm that any agreed upon repairs have been made and the property otherwise remains in the same condition. And then there's more to that paragraph about the seller having the utilities on and systems and equipment operational, so forth and so on. But that is more the intent. The contracts have always had that intent because it says buyer and buyer's representatives have the right to enter the property up and including immediately prior to closing. They've just tried to clarify that basically says even after due diligence. And again, it is with reasonable times and immediately prior to closing. So this is going to be a contractual issue that the buyer and the seller agree upon when they sign this contract. But as far as a practicality issue, the seller still owns that home and lives in that home. So this might be a discussion between the agents representing the parties regarding what has to go on and lock boxes and leaving lock boxes on or taking lock boxes off. So just an interesting clarification just to make sure everyone is on the same page. I'm interested, comment below your thoughts on that addition. All right, moving on, for some legalese under the brokerage section, GAR has added the sentence that the brokers are express third-party beneficiaries to this agreement. In other words, brokers are getting compensated in commissions for performing a good and valuable service to the public. And then what I have discussed regarding in the disclaimer about the propensity for the property to flood and flood zone certifications, we've talked about that throughout the brokerage agreements. That has been included also in the purchase and sale agreement. So that is already been discussed. And then under the risk of damage to the property, they've added reference to that new form. Watch one of the other videos before on the new form, that the property shall remain in the same condition as it was, including what was stated on the seller's property disclosure statement, or they've added a reference to that new form, the seller's disclosure of latent defects and fixtures checklist as of the offer date. And then they just made one slight change. They added, it says, notwithstanding the above, if the property is destroyed or substantially destroyed prior to closing, and then it goes on what the recourse is for the buyers and the sellers. It used to say last year, destroyed or substantially damaged. So they've changed substantially damaged to substantially destroyed. And then just two more changes. So the other change is under the miscellaneous section under paragraph C4, not miscellaneous, but other provisions under the GAR forms, Georgia Association of Realtors forms. This is interesting. If any of you have been in any of my CE classes, you have heard me say this in every single class, that regardless of any contract, if it goes to court, a judge can change anything. A judge has full authority to decide whatever a judge wants to decide regarding any dispute regarding a contract. So GAR has actually made that more prevalent, or has actually spelled that out in the purchase and sale agreement itself. So under the GAR forms, it talks about the GAR forms are issued by the Georgia Association of Realtors, that no party is required to use any GAR form. That has been in there, and they are generic with the interests of both the buyer and the seller in mind. It does say that if any party has questions about their rights or obligations with respect to what they are agreeing to in the GAR forms, they should consult an attorney. That has all been in there. Here's the part they added for 2021. Provisions in the GAR forms are subject to differing interpretations by our courts, other than what the parties may have intended. At times, our courts may strike down or not enforce provisions in our GAR forms as written. No representation is made that the GAR forms will protect the interests of any particular party or will be a fit for any specific purpose. So, it goes on to say that the parties hereto agree that they are used in accordance with the licensing agreement, so forth and so on. So again, as I mentioned, if you have been in any of my classes, you have heard me say that anyone can sue anyone for anything regardless of what the contract says, and it is up to a judge, and the judge has final authority over the interpretation, and depending on how the cases have been presented, to rule on the contracts if there's a contract dispute regarding how the judge wants to rule. So it's just interesting to me that GAR has actually spelled that out in the purchase and sale agreement itself, that the courts and a judge do have differing interpretations and can enforce or not enforce anything written. And then the last change has to do with the survival paragraph. So we're in this same paragraph, C4, under other provisions and under survival. So they have added another item that survives closing, and you guessed it, it has to do with the property taxes, since they added that in the proration section. So what survives the contract in a GAR contract, now, if you are helping a buyer and a seller and they go binding under a different contract, what survives that contract is completely different. The survival terminology, this is just specific to GAR. So what it states is the following shall survive closing of this agreement. 1, the obligation of a party to pay real estate commission. That's been in there. 2, any warranty of title. That has been in there. 3, all written representations of the seller in this agreement regarding the property or neighborhood in which the property is located. That's a slight change. It used to say all representations of the seller. They've added the word written. So now in 2021 it says all written representations of the agreement, written representations of the seller in this agreement regarding the property or neighborhood. Number 4, the section on condemnation, that's been in there. 5, this is a new section. The obligations of the parties regarding ad valorem real property taxes. So they have added that to the survival clause regarding the proration, not only the proration of the property taxes should the buyer and the seller need to prorate after closing, but also that regarding that liability paragraph that they have added in that I've already touched on. So that's a brand new section to the survival closing. And then, of course, number 6, which has been in there, any obligation which parties herein agree shall survive the closing, or may be performed or fulfilled after the closing. And again, as I mentioned in my classes, you agents, y'all need to remember the magic words. This provision shall survive closing. And those are magic words in order to make those obligations survive the closing, because of what it says, that any obligations the parties herein agree shall survive the closing. So what do I mean by that? Well, there's nothing in the survival paragraph about repairs. There's nothing in the survival paragraph about seller's obligation to pay for a home warranty for the buyer. So if you are agents and you're working with the buyer and the seller, and throughout the course of the contract or the amendments, if you guys negotiate, for example, that the seller is to pay for a 1-year home warranty for the buyer, and it doesn't happen at closing, and so it's not on the settlement statement, it doesn't happen at closing. So a week later, the buyer calls the buyer's agent and says, hey, where's that home warranty? I need information on that. And the buyer's agent calls the listing agent and says, the buyer's agent calls the seller's agent and says, hey, guess what? We forgot to call in that home warranty. So I need for you to call it in and have the seller pay for the home warranty for the buyer. And the seller's agent says, so sad, too bad. That did not survive closing, and we have already closed. The buyer's going to have to pay for their own home warranty policy. And the buyer's agent says, so sad, too bad. I watched Dana's videos and have taken Dana's classes. And remember, I used that magic phrase, this provision shall survive closing. So the seller is contractually obligated to purchase that 1-year home warranty for the buyer, even though it wasn't done after closing, because the parties agreed this provision shall survive closing. So that's very important, a magic phrase to use, again, for things like a home warranty, for repair issues, any of those things. And then the last thing, and again, I have mentioned, is the phrase that the phraseology or the intent that GAR has used before every signature line in all of the forms. And it's just slightly modified, whether it's a brokerage agreement or a lease agreement, so forth and so on. So in the purchase and sale agreement, it specifically states, by signing this agreement, buyer and seller acknowledge that they have each read and understood this agreement and agree to all its terms. So that, again, admonition or reminder, I should say, that the public has read, understood, and agreed to what it is in those forms before they sign it. That has been added to the purchase and sale agreement. So that's it. What do y'all think? Comment below. Love to hear your comments. Stay tuned for a couple more contract tips on the changes that the Georgia Association of Realtors has made on their contract package for 2021. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.